Good evening, friends. In the process of AIBE exam preparation, we have covered the important topics like IPC, CRPC, CPC, Constitutional Law, and Indian Evidence Acts based on the previous year's question. Each topic, which covered more than 100 questions of the previous year, we can expect at least 3 to 4 kind of a repeated. So that will take care at least about 20 questions, 20 to 30 questions we can expect on that. And remaining topics also we are now covering. And today we are covering with the family law, where we can expect at least 8 questions. So out of which, based on the previous, we can comfortably expect 3 or 4 questions. Okay, I hope this will be useful. So let us start. The Hindu Marriage Act 1955 does not permit any party to the petition in which a decree of restitution of conjugal rights has been passed to apply to the court for a decree for divorce by showing that there has been no restitution of conjugal rights as between the parties of the marriage for a period of 1 year or upwards after passing the decree. It does not permit any party to that. That is answer. The offences under the Prohibition of Child Marriage Act 2006 are cognizable and non-bailable. 2006 Prohibition of Child Marriage Act, it is both cognizable as well as non-bailable. Which of the following sections of the Hindu Adoption Maintenance Act 1956 deal with the amount of the maintenance? Section 23 of HAMA 1956 deals with the amount of the maintenance. Which of the following statements are false for the purpose of the Hindu Marriage Act 1955? It is assumed that the person who is not a Muslim, Santal, Christian, Jew, Parsi by religion is considered a Hindu. A person who belongs to Lingayat subsect is assumed to be a Hindu. A person who converted to another religion needs to follow the local ritual customs for converting back to the Hinduism. Which is the false is the answer question. So the third one is the right answer. A person who converted to another religion needs to follow the local rituals is a false. In which of the following cases it was held that the rights conferred under the section 25 of HAMA 1956 Hindu Adoption and Maintenance Act 1956 supersedes any contact to the contrary, the fact that the date of decree makes no difference? This is a case where Sesi Ammal versus Tayu Ammal. On which of the following dates the Hindu Marriage Act 1955 come into the operation? It's 18th May 1955. 18th May 1955 HMA 1955 came into operation. Which of the following properties will section 30 of the Hindu Succession Act 1956 govern? Options: Tarvand, Tawali, Kutumba, Kavaru, Ailam. Answers are Tarvand and Tawali. These are all the things, properties of the section 30 of the Hindu section are governed. Which of the following sections of the Muslim Personal Law, that is Shariat Application Act 1937, have been repealed or amended by section 6 of the Dissolution of the Muslim Marriage Act 1939? Section 5 is repealed. Requisites of a valid adoption: no adoption shall be valid unless person adopting has the capacity and also the right to take the adoption. Person giving in adoption has the capacity to do so. Person adopted is capable of being taken into the adoption, and the adoption is made in compliance with the other conditions of the adoption. So answer is section 6 of the Hindu Adoption and Maintenance Act deals with these things. According to the Muslim Women Protection of Rights and Marriage Act 2019, any pronouncement of talaq as defined under the act by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whatsoever shall be void, and it is also offence cognizable and compoundable offence. This is called the famous triple talaq verdict. Now triple talaq is banned. It is a void, cognizable and compoundable offence. Hindu Section Act Amendment Act 2005 provided for women the compulsory rights as par with the men, that is equal rights, and inheritance rights in agricultural land from her parents at par with her brothers, inheritance of the self-acquired agricultural land by her deceased husband, all of the above. 2005 Amendment Act on the Hindu Succession, before which there was no rights for the women, and 2005 it gives the rights to the women at par with the men in all respects. Section 25 of Hindu Marriage Act provides the permanent alimony and maintenance. Section 25 of the Hindu Marriage Act is a permanent alimony and maintenance. A Hindu wife which had been living with her children, and all the children had been brought up by her without any assistance and help from her husband for many years, the wife was entitled to separate residence and maintenance under the section A2 of 18 of the Hindu Adoption and Maintenance Act. Section 18(2)(a) gives the right for her to get the entitlements for the residence and maintenance. On and from commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by the Mitakshara law conferring on the daughter the co-personary status by substituting a new section called Section 6. Section 6 of 2005 Hindu Succession Act gives the rights to the daughters. Section 5 of Hindu Marriage Act is the conditions of the Hindu Marriage Act. Important, like there is no polygamy and various different conditions are there. That is Section 5 gives the conditions for the Hindu Marriage Act. A girl of 22 years marries her maternal uncle's son of 23 years in accordance to the Special Marriage Act. Such marriage is void. There are certain prohibited relations are there, and this is one of this one. But again there is an exception. Sometimes these are all valid based on the culture and all that. So anyway, here the answer is void. Okay. Under the Dissolution of Muslim Marriage Act 1939, a Muslim wife can seek dissolution of marriage if the husband fails to perform the marital obligations for 3 years. If husband fails to give a marital obligations for 3 years, a Muslim married woman can seek the dissolution of the marriage. The case of Muhammad Alahaddin Khan versus Muhammad Ismail Khan is referred to acknowledgement of paternity. Paternity was also one issue. So acknowledgement of paternity was in the case of Muhammad Alahaddin Khan versus Muhammad Ismail Khan. In which of the following cases Supreme Court in 2017 declared the pronouncement of the talaq 3 times at a time by a Muslim husband as unconstitutional? It is a Shaira Banu versus Union of India. Very popular, Shaira Banu versus Union of India. Which of the following provisions of the Hindu Marriage Act 1955 incorporates the fault theory of the divorce? That is a section 13(1) and 13(2). Both are correct answers. Section 13, if you give also, I think it will be accepted if there is no other option. Under the Hindu Maintenance and Adoption Act 1956, which of the following circumstances can dependent enforce his right to maintenance against the transferee of an estate out of which he has a right to receive the maintenance? It is in the 2 circumstances: only when the transferee has notice of such right, and only when the transfer is a gratuitous. Then it can be accepted. It can be enforceable. Which of the following provisions of the Hindu Succession Act 1956 lays down for the escheat? Escheat is the government taking away land in absence of any heir. Section 29 of the Hindu Succession Act 1956 talks about the escheat, section 29. If a man marries a girl who is within his prohibited relations and his custom does not permit such a marriage, such man would be punishable under the section B of 18. Section 18B of Hindu Marriage Act. Any prohibited relationship, marriage with a prohibited relationship which is not permitted by the customs, is punishable. Which section of the Hindu Marriage Act 1955 provides the child from a void marriage would be legitimate? Section 16 talks about any child even with a void marriage also will be considered as a legitimate, and the necessary benefits can be obtained from the spouses. Section 19 of the Hindu Adoption and Maintenance Act 1956 provides for the maintenance of the widowed daughter-in-law. Widowed daughter-in-law also is, she can claim under the section 19 of a HMA. Section 30 of the Hindu Succession Act 56 deals with the testamentary successions. Section 30 talks about the testamentary successions. Option of the puberty is a ground of the divorce under the Hindu Marriage Act for only wife. Option of the puberty is a ground for the divorce only for the wife. Which section of the Hindu Marriage Act provides the child from a void marriage is a legitimate? We already discussed section 16. A child born even in a void marriage is considered the legitimate. Which of the following is essential for a valid adoption under the Hindu Marriage Act? Actually giving and taking of a child. Both should be capable. There are certain conditions under which adoption can be accepted under the Hindu Marriage Act. A Hindu male can adopt a female child if the difference of the age between the two are minimum 21 years. So similarly for the woman adopting the male also, there is an age difference. So we have to consider these two factors. Which of the following relation is not dependent under section 21 of the HMA? Grandmother is not considered as a dependent under the Hindu Adoption and Maintenance Act 1956 as per the section 21 of the Act. Hadith is one of the sources of the Muslim law. Hadith is words and actions of the Prophet. Hadith is one of the sources of the law, like Quran, and similarly Hadith also there. That is the words and actions of the Prophet. Shah Banu case was related to maintenance of the divorced Muslim women. Shah Banu popular case, after which again there was a change in the act also. So maintenance of divorced Muslim women. Which of the following is not a legal guardian of the property in the Muslim minor? Brother is not a legal guardian. A marriage with a woman before the completion of her iddat is irregular. As you know, the iddat is a period in which a divorced woman has to wait for before the next marriage. Within the marriage, if the marriage is there, then it is considered irregular. The family courts have concurrently jurisdiction to pass a decree for dissolution of marriage under the Indian Divorce Act. The case which is order was passed on is Dr. Mary versus Dr. Vincent. Who of the following Muslim is not entitled to maintain? An illegitimate son is not entitled to maintenance. In fact, as per the section 16 of the Hindu Marriage Act, even a person of the void marriage is also considered as a legitimate. In case of a Muslim law, a person illegitimate is not for he cannot claim any maintenance. The AIBE school presumes that a family, because of it is joint, possesses the joint property. There is one of the statement is correct or not. This is incorrect. So we have to see what is the AIBE school and what are the rules. Okay. You can take the Hindu Marriage Act and Hindu law also. Bare Act you can take to the exam hall. Deferred mahar is payable at the time of divorce or at the time of death of the spouse. This is true because there is also a provision for the deferred meher also. On Sunni law, it is true, whereas it is not true in case of other Muslim laws, like Shia's laws. The last amendment to the Indian Succession Act was made in 2002. Indian Succession Act was made in 2002. In fact, there is an amendment. This is an old thing. Amendment in 2000, I think 17. That also we have to remember. Which is the correct statement? There can be a will without codicil. Codicil is something amendment to this one, and always there can be a will without any codicil. As per the section 63 of Indian Succession Act, the will should be attested by at least 2 or more witnesses. Section 63 talks about the witnesses for the Indian Succession Act. 2 or more witnesses required. Iddat under the Mohammedan law refers to, as discussed, it is a period in which after the dissolution of the marriage, the woman has to maintain the minimum period of the iddat before the remarriage. So here the statements, a gift made on the occasion of marriage, a right of the husband to divorce attaining the puberty, none of them are correct. Under the Christian Marriage Act, the marriage registrar of any district is appointed by a state government. In a Special Marriage Act and the Christian Marriage Act, the registrar is appointed by the state government. Under the Hindu Adoption and Maintenance Act, the person who is taken in adoption must be only Hindu. That is the answer. Polygamy was permitted for Hindus before 1955. 1955, where the Hindu Marriage Act came into the picture on 18th May 1955, the polygamy is abolished or it is prohibited. Now the polygamy is a punishable offense. Mohan gets married to his sister's daughter Kriti. This is something like a niece marrying the niece. The marriage is otherwise prohibited, but if the custom says it is, custom allows, it is valid. Some of the areas in India, like North India, South India, this kind of differences are there with respect to the customs of the marrying the own family members. Which of the following heirs is not class 1 heir under the Hindu Succession Act 1956? Father is not a class 1 heir. Natural guardian of an adopted son under the Hindu Minority and Guardianship Act 1956 is adoptive father is a natural guardian. In respect of the family relations, the law applicable in India is personal law of the parties. Any personal law, family relations is the personal law of the particular parties is applicable. What should be the difference of the age under the Hindu Adoption and Maintenance Act? If female adopts a male, it is again 21 years. If male adopts the female, also 21 years. If female adopts a male also, the difference of age should be 21 years. A person cannot be a next friend, guardian of a person if he is a minor or if he is the opposite party to the suit or he has not given a consent in writing. All of these are correct. In which of the Hindu Succession Act 1956 the law Mitakshara has been incorporated? This is where the conditions of the Hindu Marriage Act, Section 6, Section 5 and Section 6 are taken into the consideration while making the Hindu Succession Act 1956. Particularly in the Hindu Marriage Act, it is Section 5. Hindu Succession Act, it is Section 6 of the Mitakshara. Hindu's widow, if there are more than one, shall take one share for all the widows. All the widows, only one share, they will get it. Maintenance application under the Section 18(2) of the HAMA, that is Hindu Adoption and Maintenance Act, is filed in the district court. This is the lowest court wherein the Maintenance Act, under the Maintenance Act application can be filed. Lowest court is the district court. Onus to prove the reasonable excuse for withdrawal from the society of other is on the respondent. Respondent has to prove that there is a reasonable excuse to withdraw from the society. A disqualified person or a heir may or may not transmit an interest to his or her own heir as per the discretion of the court. A disqualified person, Section 25 of the Hindu Marriage Act, Hindu Succession Act also talks about that, like a criminal sometimes it disqualifies. So he may or may not transmit an interest to his or her heir as per the discretion of the court. Talaq-e-tafweez is the talaq by delegation, where the husband delegates somebody to pronounce the talaq to his wife. That is a talaq by delegation. Talaq-e-tafweez. Any movable property possessed by a female Hindu acquired before or after the commencement of the Hindu Succession Act shall be held by her after the commencement of the Act as a full owner. So as a full owner he can possess. Conditions of the Hindu Marriage Act have been laid under the Section 5 of the Hindu Marriage Act. Hindu Section Act 2005 allows all daughters of the deceased equal rights with the daughter, allow sons of the deceased equal rights, allow daughters of the deceased equal rights. Here it allows all the daughters of the deceased equal rights with the sons. So sons or daughters will have an equal right as per the Hindu Succession Act Amendment 2005. A is the mother of the B. She becomes a widow and remarries. B dies. Can A succeed him as a mother? For both are Hindus. Answer is yes. Referring to Section 6 of the Hindu Minority and Guardianship Act, Supreme Court observed that the words after him does not mean that after the lifetime of the father. Indeed, it means in absence of, if the father is a non-functional as a guardian for various reasons like indifference, physical or mental levity, or away from the place where the child lives with the mother, or by mutual understanding, it may be treated as the absence of the father. In which case this is taken? Gita Hariharan case, it says after father or after him, means it is not just after the death but even before that under certain circumstances. That is a Gita Hariharan case. By a recent amendment, the daughter of a co-personaire by birth becomes a co-personaire in her own right. This is as per the Hindu Succession Act 2005. Shamim Ara versus State of UP. This is a case related to the condition precedent for a Muslim husband for rendering divorce is the pronouncement of the divorce, which has to be proved on evidence. Section 9 of the Hindu Marriage Act talks about the restitution of conjugal rights. The daughter is equated with the son in the property Hindu Succession and Amendment Act 2005. Mubarat under the Muslim law. Mubarat under the Muslim law refers to the dissolution of the marriage with mutual consent. Mubarat is with a mutual consent, not just by a talaq. Discriminatory aspects of the Section 10 of the Indian Divorce Act, now changed as the Divorce Act, were removed by the Indian Divorce Act of 2001. Whatever the discriminations with respect to the Section 10 of the original Indian Divorce Act changed to the Divorce Act with amendment in 2001. A Sunni Muslim marries with Kitabiya girl is a valid. Kitabiya girl is a valid for the in Muslim law. The dissolution of the Muslim Marriage Act 1939 is based on the Maliki schools. There are so many schools are there, Hanafi, Shafi, Maliki and Zaidi. So dissolution of the marriage is based on the Maliki school. Under the Hindu Adoption and Maintenance Act 1956, a female Hindu has the capacity to take a son or a daughter in adoption if she is not married. If she is married, she cannot take it. Then again it is a various other conditions like wife and husband having no children or no possibility of the children, kind of a situation. Okay. If she is not married, who is an elder and who is a capable can adopt. A child born of a void and voidable marriage under the Hindu law is legitimate. Friends, these are some of the questions that appeared in the family law. So once we refer to this one, it's as simple as that Hindu Marriage Act, whatever the sections, we can just refer to that with the bare act, and other important laws with respect to the Muslim. See, and generally there it is difficult to get a bare act without notes, so we have to find out, because it is clearly said printouts are not allowed, even if it is a bare act also. You have to have only published books for that particular purpose. Okay. Anyway, I wish you all the best, and in the next session we'll be talking about the another topic, that is with respect to the law of contracts, where you can expect at least 8 questions. Thank you very much.